Hello, everybody. Welcome to our MCLE on the right to privacy. Is anything left? I'm actually going to stop sharing right now. Now, to the screen share. Right. Welcome, everybody, to our fall MCLE series. This is for November. The right to privacy. Is anything left? Presented by James Wood, Esquire, facilitated by the AIDS Legal Referral Panel. So our agenda is to do the overview of ALRP in the panel, followed by the substantive training and the question and answer session afterwards, and then followed by evaluations and wrap up. The training is being recorded, and all participants, except for the hosts, are muted. You may enter questions in a question and answer function at the bottom of your screen. We will address them after our presentation. For that, I will read the questions to Jim, and then he will answer, and we'll take them in the order they appear. So in order to receive credit for the MCLE, you must complete the evaluation. I will send a link at the end of the session, and you will receive your MCLE credit within the next couple days. And of course, if you don't receive your credit, after a few days, please let me know. So ALRP's mission is to advance and protect the rights, dignity, and health of people living with HIV/AIDS in the Bay Area. ALRP is often the last line of defense for clients who are at extremity. In 2024, we handled 2,000 plus matters with nearly 1,300 unique clients assisted. Now, 55% of our clients are living on an income of $15,000 or less. So as I said before, in many cases, ALRP is the only place they can turn for legal help. So we're able to do that because we rely on our panel to provide low-cost legal counseling and representation on just about any practice area. For panel attorneys who are thinking of joining, we tailor the experience to your experience and availability, and we only ask that panel attorneys. Cat's bothering me. That's why I'm stuttering over my words. We ask that panel attorneys only accept 2 referrals a year, and of course, they have the complete option to accept or deny a referral when we contact. Panel attorneys, of course, receive free MCLE trainings, mentoring, and malpractice insurance. Very important. And other legal resources. We are partners with a large number of other organizations in the Bay Area and do partner with a large number of law firms as well. So if you would like to join the panel and help out the community, hit the link. I will send you a link when I send the eval, or give me a call at 701-1200 extension 321. I'd love to talk to you. If you're not an attorney, or if you simply don't have the time to join the panel, well, there are other ways to help, volunteer, or donate, because money makes the world go round. There's the donate link, or you can contact Sloka there and his email. And I'd like to thank our co-sponsors, too numerous to name, but there are so many great organizations doing a lot of good work in the area, and we're proud to have them as co-sponsors. And we also work with different presentations, and recently we even had Bailiff helping us out with a large Willathon session we had back in September. So please take a look at them and what they have to offer when you get the chance. Our presenter is James M. Wood, Esquire, who has been a panel attorney for a number of years and is one of our most esteemed panel attorneys. And thank you so much for presenting on a topic that's incredibly important, especially given the current political climate where it seems like rights are being trampled on everywhere and privacy is now seemingly at the mercy of the man in the White House. So thank you, James, so much for presenting, and I will stop my screen sharing and allow you to pull up your slides.
All right. There. Well, thank you so much, Jake, for this. And thanks for the opportunity to present on privacy. pull the curtains back, and this was kind of a scramble here at the. I'm technology challenged, and Jake was very kind to help me get this going. So thank you, Jake, for your help and your patience, everybody's patience here as well today. And let's start with a paraphrase of Charles Dickens. It's the worst of times. It's the worst of times. We're seeing an assault on every possible civil right that we have, and they're not excluding any population of people. And the goal of this program today is to focus on whether or not anything is left to privacy with those affected by HIV/AIDS. And we're going to talk about the right that seems to be ignored by Trump and his allies, that each of us has um, a right, regardless who we are, where we are, and how we choose to lead our lives. And really, this is about the right to be left alone. And as one court put it, no right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from restraint or interference of others. But we don't see that really, do we? You take a look at the Instagram assaults and kidnappings by ICE throughout the country in Oakland and San Francisco. Uh, but hopefully we can take some lessons from today and apply it to those who are victimized by Trump and the administration. I did provide a number of materials for the program, and the first is a ALP monograph on confidentiality that's available on the ALP website. It's a 36-page monograph that I helped edit and revise 4 or 5 years ago, and it's really a go-to point for any type of research materials that you want about AIDS and privacy. Next, I included a sample cease and desist letter. I got a call a week or so ago from an ALP attorney telling me about an individual who did not want to sue, but simply wanted to make sure that the individual who was disclosing their HIV/AIDS status would stop. And one way of preventing this from happening is to write a cease and desist letter. We'll talk about that in a little bit. I also included a summary status of HIV privacy since 2023, a quick, very brief summary of applicable statutes and legal framework for that, some reported case decisions since that time, Supreme Court rulings that we'll touch upon since 2023. And finally, I've included a sample demand letter that you might find useful pre-litigation, that outlines the facts of the case, the facts of disclosure, summary of applicable law, and then ultimately the demand. So I hope that you find those materials useful. There's my contact information. I'm always willing to help anybody at all that's got any type of question about a case or an individual and how to help that. I'm retired. I've left big law. I don't know when it was. It feels like a lifetime ago, but a good lifetime ago. And right now I'm spending all of my time working with a number of immigration groups here in the East Bay, fighting ICE and the assaults on individuals here. But my passion is and always has been working with individuals affected by HIV/AIDS. So I'm always willing to hear from anybody that wants to kick around an idea. I took a quick look this morning to see what's happening to the population. And unfortunately, I think most of us know that since 2023, there's been a rather significant increase in HIV/AIDS in the population living in San Francisco. And the cases primarily are affecting Black Afro-American residents who have seen a double increase in the number of cases in San Francisco. Cisgender women, the Latin community bears a disproportionate share of new cases, with over half of the new cases in the 9-county Bay Area among Latinos. And, even without the stigma of AIDS, they're suffering the stigma of living in the Bay Area with a different colored skin. And then transgender women, there's also been a significant increase in a number of HIV/AIDS. And so these are very vulnerable people, individuals who whose right to privacy and the right to be left alone is really threatened every day. We're living in a world where, let's just say it, that there is no privacy. Um, the internet and the access to our personal private information is available to many, many people, either by the type of stuff that we put on the internet or Facebook or Instagram or whatever it is that we're using for social media. And this is a way to help protect and retrieve the privacy rights that we might have or that our clients might have. Oh, sorry. Told you I was technology challenged. The United States Supreme Court, for a very, very long time, and it seems like a very long time ago now, recognized the right to privacy, and in many, many different cases have recognized the right and affirmed the right until Trump won, when he packed the court with individuals sympathetic to his point of view. And this Clarence Thomas has been waiting for this day. He's been waiting for his day when he is in the majority, and particularly in the areas of privacy, he has been a champion of getting rid of privacy rights among the vulnerable populations. Privacy, as we know, has been embedded in our culture for decades, including laws voiding sodomy rights, decisions upholding until recently the right to choose. That's the first crack that is beginning. The right to marry a person we love, and the right to contraception. The court, and we'll get into this a little bit later, but has found that even though there's no explicit right to privacy enunciated in the Constitution, unlike California's Constitution, there's no right to privacy enunciated. So what they have done is taken a look at the various amendments, the 14th Amendment primarily, and due process clause, and finds that within the due process clause and other elements of the amendments that they can find a right to privacy. They've interpreted the 15th and 14th Amendments to protect people's substantive rights. But Clarence Thomas has always been the advocate that these rights are non-existent. And he noted this in the Dobbs decision, which overruled years and years and years of protection to a woman's right to choose. And he noted that in future rights, we're going to reconsider whether or not due process protects the right to live, love, and marry those that we love, same-sex marriage, same-sex consensual relations. And he's just been waiting for the chance to begin to do that. The chance, ironically, came up a week or two ago in the case of Masterpiece Cake Shop versus Colorado Civil Rights Commission. And that was the case of Ms. Kim Davis, who objected to creating a wedding cake for a gay couple that wanted to celebrate their wedding with a cake. And she came back again, appealing, asking the court to overrule the right to marry people that we love. And the Supreme Court decided not to hear the case. That was an opportunity, and she put it on the table of Obergefell, of taking a look as to whether or not the right to marry is a constitutional right. People feared that this was the opportunity for Clarence Thomas to get his wish to overrule the right to privacy and the right to choose who we love. And the Court of Appeal, I'm sorry, the Supreme Court ruled a couple of weeks ago that they weren't going to hear the case. So the lower court decision um, upholding Obergefell stood. You know, lots of groups said this is it. This is the end of Clarence Thomas's attack on the right to marry. But I think that a closer reading was that, you know, bad facts make bad law, and they recognized that they weren't going to decide the right to marriage over a cake. But you know, Clarence Thomas and other conservatives on the court have made clear that at some point they're going to take a look at the right to privacy as a part of substantive due process. And we're going to have to prepare for those days. We're going to have to prepare for those arguments. And in the meantime, we're going to have to make sure that we can use the right to privacy under the United States Constitution in a way that protects our clients. So Mike Johnson, you know, another, well, let's leave the pejoratives alone, is also an enemy of the right to privacy and is out there clearly against our community. He has made clear that he is going to target the right to marriage, and he's found an ally in the Supreme Court. The program, as Jake mentioned, I'm going to go through talking about the stigma of HIV/AIDS, because the stigma really is the source of the impact of disclosure of an individual's HIV/AIDS status. Stigma is a very real, sadly, tragically, factor in the United States culture, and it is really the source of all efforts to protect the right to privacy, and ironically, the source of efforts to violate an individual's right to privacy. Talk about constitutional rights, both federal and state. Talk about common law and how it is that we can use common law and the right to privacy to protect an individual's right to privacy. These are really, all of these are really great resources for doing any type of legal research in terms of finding what a particular state's law is on the right to privacy in the HIV/AIDS context. Also to take a look at cases that have been decided, Court of Appeal cases, jury verdicts, and so on. All of them are excellent resources in beginning to understand further the right to privacy, as well as remedies for a violation of right to privacy. Since I first began to do this program, we now have another resource, and that's the AI resource. I was a skeptic of it. It's now my go-to place for doing basic research. And I mentioned earlier, too, in the materials that I gave you, there's a cease and desist letter that I sent on to the LRP Council for the case that they were working on. The letter was drafted by Perplexity. It was a very simple process. I found I put in the essential facts of what the claim was, asked them to refine it to California law, and it created a pretty remarkable demand letter. Well, you be the judge of that. But for me, it's now in my 4 books for demand letters and cease and desist letters. But you know, we've all read and heard about cases where attorneys have submitted briefs citing cases that either non-existent or cases that were inaccurate in this description of the law. You know, AI is early. We have to recognize the limits that AI has. We have to double, triple check all sources that we cite. But in writing the demand letter, I found that the sources were accurate and it was complete. So that's also another good resource for investigating other cases similar to yours and so on. Um, since the onset of the U.S. AIDS epidemic in 1981, sadly, stigma and discrimination have detrimentally affected people with HIV in every aspect of their lives, and that continues. Nothing has changed. The stigma is there. The stigma is very real. And people continue to suffer from uh, the stigma placed upon them for being sick. It's affected them in every aspect of their lives, including employment, insurance, education, housing, healthcare, and relationships with people that they love. And I think, too, that the understanding of the stigma of HIV/AIDS and the impacts that the stigma that is put on people is critical to understanding really what the right to privacy is and why it is so critically important that an individual's right to be left alone be maintained and preserved in spite of a condition that they might have. Um, in the materials, I cite a case that essentially says that HIV/AIDS is just not another illness. The court continues, it carries it with a unique stigma that can insidiously affect almost every aspect of the client's life, awfully completely cutting them off from social and familial ties. As a consequence, most HIV positive people keep their diagnosis secret, hidden from others, hidden from employers, co-workers, members of their schools, members of their churches, families, and friends. And as they say, it carries the stigma impacts every aspect of their lives. The right to privacy, too, is very, very fragile and can destroy, when disclosed, can destroy an individual's life as they've been trying to live it. As I mentioned, from the very beginning of the epidemic, the stigma and discrimination was and is rampant, based largely on the perceived infectiousness of people with this condition and pre-existing stigma against the groups most affected at the time. And what we see among the population in the country, that they, in order to preserve their power, they want to focus on a particular group of individuals. And in attacking that group of individuals, they kind of sickly see a way of preserving and increasing their power. And we saw that with the African American communities from the time of slavery that continues until this day. We saw that with Japanese Americans at the time of World War II. We see it anti-gay marriage, and once marriage was confirmed by the Supreme Court as an inherent right, we see the stigma and the hate transferred now to trans people. And then we're seeing it transferred to Latin Hispanic people. And they just, endless feeding upon discrimination of groups of people. And discrimination against these groups of people really has never gone away. They say that the North won the war, but the Confederacy, the South won the narrative, and that narrative continues. The stigma and the impact of a disclosure of an individual's HIV/AIDS status has, like I mentioned earlier, significant impacts on their day-to-day life. It has impacts on loss of income and livelihood, loss of marriage and childbearing options, poor care within the health sector, insurance issues, withdrawal of caregiving in the home, emotional impact of loss of hope and feelings of worthlessness, loss of reputation, denial of health care, and so on. The stigma is alive and I don't want to say thriving, that's too kind of a word, but it's a sickness that continues to pervade our society. One, excuse me, of the ways that society and groups are uh, working to fight the ongoing stigma is the Zero HIV Stigma Day that's observed on July 21st of every year. It's an international um, uh, day of identifying and uniting individuals and communities and organizations and nations to take collective action, to take real collective action against continuing to fight the, uh, the stereotypes and misinformation that is out there about HIV/AIDS. There was 2025 theme that on July 21st this year was HIV stigma warriors that focused on developing champions of advocates of people who name the stigma, who identify the stigma, and to find ways to inform people, inform populations that the stigma is very real and ways to prevent it. It's a call to action and a celebration of resilience for those living with HIV. And again, this is a great resource for individuals who may have a claim for a violation of their privacy and who are then become subjected to the stigma. Again, very, very real in our society. Considering the stigma as well as the right of an individual to be left alone identifies why it is that privacy matters, why it is that privacy is important as a shield. There are all different kinds, have been all different kinds of privacy, some of which I usually include in briefs or uh, cease and desist letters or demand letters. But the right to be left alone was really recognized first by Justice Brandeis in 1886, that the makers of the Constitution conferred the most comprehensive of rights and the right most valued by all civilized men, the right to be left alone. Urbaniak, what is that, 35 years ago, in a case involving the right to privacy, clearly and accurately identified that the impact of the HIV positive status and the disclosure of that needs to be protected. And it needs to be protected because of the false associations that are made and characterized by people who are sick. And it recognized that a remedy of tortious invasion of privacy should exist and does exist. The examples that we can identify as privacy violation are probably as big as we can think of, or what it is that we've had in our experience. And these are a few of them, the kinds of violations that can happen to an individual who comes to the LRP or other organizations saying that they've been the victim of a disclosure, unconsented to disclosure of HIV/AIDS. And all of these have, as we see, resulted in significant claims against these individuals who, either inadvertently or intentionally or negligently disclose a person's HIV status. Let's first talk about kind of the constitutional right to privacy. Then we'll, as I say, that we'll get to the statutory right to privacy and then the common law right to privacy. And we'll begin with the United States Constitution. As I mentioned earlier, in the good old days, where there was a reasonable balanced court, the court did find in many, many instances that inherent within the Constitution inherent within the spirit of the writers of the Constitution, inherent in the uh, growth of the nation, that there was an inherent right to privacy implied in the First, Fourth, Fifth, Ninth, and 14th Amendments. Now, that right to privacy only goes so far. The courts have recognized that the Constitution only protects actions by state actors. That is, by first people either as working within government or under the color of state law. So unfortunately, there's that limitation. And that's really been the basis of recognition of privacy and a person's right to marry, a person's right to purchase contraceptives, and so on. But nevertheless, it's an important point to point out in any type of brief or demand letter or whatever, that within our country, within our collection as citizens, there is a right to privacy. The remedy may be different, but there is inherent, and this being chipped away, but there is inherent right to privacy within the Constitution. Again, inherent right to privacy in the Constitution. The Constitution may not provide a remedy, but it provides the right, which can be built upon by recognizing the right to privacy in common law and in state law and in state constitutions. So even though it's, state actor, I never avoid or neglect to point out that there is a right to privacy within the Constitution. For how long? I don't know. That was then. This is now. Let's begin with the perspective of the Supreme Court on gay sex, because this is what might be said to be the rock bottom of privacy, as well as where we can expect the majority of the Supreme Court to return with its doctrine of originality. And in Bowers versus Hardwick, the court was dealt with a case of an individual observed in his home by a Georgia police officer while engaging in sex with another adult in the bedroom of his home. He was charged with the sodomy law in Georgia, and he challenged the state's constitutionality in federal district court. The court dismissed it. The Court of Appeals reversed and remanded, holding that Georgia statute was unconstitutional. But then the Supreme Court got a hold of it and went back, to its concept of originalism, which I don't understand how they do that. I don't understand how it is that, when the Constitution was penned hundreds of, everything froze in time. And I don't get it. And I don't think it's due to my liberalism. No, I'm not going to, whatever. Anyway, they found that the law was constitutional because taking a look at the time of the Constitution was written, states outlawed sodomy, so because they did it then, they can do it now. That's foreshadowing. In Dobbs, Alito's majority opinion argues the court has long been reluctant to recognize rights that are not mentioned in the Constitution. Substantive due process has at times been a treacherous field for this court, and it has sometimes led the court to usurp authority that the Constitution entrusts to the people's elected representatives. So there you have it. It's, foreshadowing the court is going to be what it is for some period of time. As Sotomayor, because of her health, steps down in the next 3 years, it's, I don't even want to think about it. So we have the federal Constitution that the courts has recognized that there is an inherent right to privacy uh, in the Constitution. But as we're beginning to see with the women's right to choose case, it's questionable how long this, the current in its current composition, will continue to recognize that right to privacy. So let's talk about the state constitutional rights to privacy. Um, California, Article 1, Section 1, the very first thing in the California Constitution is the right to privacy. And every individual within the state is guaranteed to the fundamental right to privacy. And Alaska has a similar law. That, that's always a great place to start with any type of analysis of an individual's right to privacy. Very broad, as is Alaska's law. Unfortunately, in 1994, in the case of Hill versus NC2A, the court did not take the absolute language of the Constitution, and it held that it adopted a balancing test, making it easier for government or private actors to justify some privacy intrusions. And this has long been criticized. So the important thing is that in taking a look at a privacy case, you engage I always begin with the absolute and then say, okay, let's balance this. And there are absolute ways for disclosure of HIV/AIDS status of tipping the scale in the balancing act that in favor of our clients, that no reasonable basis whatsoever for the disclosure of an individual's HIV/AIDS status, given the stigma that's associated and the impact of that on the individual in the particular case. Other states are less definitive about the right to privacy, and usually are limited to situations of a warrant or a search and seizure situation, and not the disclosure of personal health status of an individual. Excuse me. We found, excuse me, we found that, and we see that over the course of years, state legislatures have created laws that clearly have an effect of taking away an individual's right to privacy. And in these states, excuse me, among the 11 or so, they've attempted to constrain the practical effect of privacy clauses, either by statute or judicial interpretation. Legal challenges often debate whether state privacy rights protect against digital surveillance mandatory disclosures to law enforcement. So we begin to see that even within many of the states, and we can identify them readily, many of these states are chipping away at the Constitution by creating statutes in particular situations that recognize that there is a correct way, well, not correct way, but a way to invade an individual's privacy that should not be protected. Let's take a deeper look at California Constitution, Article 1, Section 1, that all people are by nature free and independent and have inalienable rights. Among these are enjoying and defending life, liberty, acquiring possession, and protecting property, by pursuing and obtaining safety, happiness, and privacy. So, that's about as absolute as it gets. Like I say, I always begin with, in any type of brief, demand letter, cease and desist letter, quoting the absolute language of privacy, and maybe anticipating, maybe not, depends. Anticipating whether or not they're going to bring up NC2A, I'd put in a balancing argument. And frankly, I believe that any type of balancing argument that NC2A insists that we take a look at that the balancing will always, as I said earlier, will always come out tipping strongly in support of the individual and protecting that individual's right to privacy. Um, the We can expect uh, with brighter opponents that they'll point out that the Article 1, Section 1 adopted by an initiative, citizens initiative, that it was intended to um, protect against unnecessary government surveillance and collection of records. Um, but as we see that there'll be cases that we'll talk about where in the area of HIV/AIDS that it's absolute. I'm going to be absolute in saying it's absolute, but there's always exceptions, and we can talk about those. But we've got the strong language of the Constitution, California Constitution, um, that supports protecting our clients' right to privacy from disclosure of their HIV/AIDS status. All right, let's talk about the um, foundation of the right to privacy in common law, and that's going to be important given the fact that the U.S. Constitution limits it to state action and kind of a little bit of ambiguity in the California Constitution. But the right to privacy, we have a strong strategy based on the common law. First, again, we talk about this resource in particular. The National Resource Center on HIV, infectious disease, sexual health, and identity is a very, very powerful resource that I always begin with taking a look at the law of a particular jurisdiction, case laws, recent settlements, and so on. And I mentioned that there are many others as well that earlier in the presentation, earlier slide, that is also a great resource for finding the common law and in a particular state and what those resources might be in helping us. All right. I look into the common law because if we have a client who comes in and talks about that a former lover or an employer or a doctor or anybody at all has disclosed their HIV/AIDS status in a way that they did not consent to, then we can take a look at potential claims and causes of action. Always begin and include in the common law with violation of the right to privacy under the 14th Amendment and Article 1, Section 1 of the Constitution. 42 U.S.C. 1983 is also a good basis, again, but limited to state action, but nevertheless something we should always take a look at in the facts, particular facts of our client and of the case. Intentional infliction of emotional distress, both negligent and intentional. We'll get into more detail about those as well. These are some representative cases in the common law that recognize and protect an individual's right to privacy given HIV/AIDS status. And Doe, the plaintiff filed a civil rights complaint under 42 U.S.C. 1983, alleging that the defendants had violated his constitutional right to privacy by revealing to the public the details of a conciliation agreement in a complaint against Delta Airlines. The court found, and we can get into this later on, but if an individual waives his right to privacy about HIV/AIDS status, then there's no right to privacy. In But in Wayland v. Roe, the court said that affirmed that there was no waiver of his right in disclosing it to an employment investigation, and said that the right to privacy can be characterized as a right to confidentiality, to distinguish it from the right to autonomy and independence, decision making from personal matters. The court held too that the extension of the right to confidentiality, to privacy, to personal medical information recognizes that there are few matters that are quite so personal as the status of one's health, and few matters the discrimination of which one would prefer to maintain greater control over. These other cases we'll talk about, but there are also important references and resources for identifying the court's recognition and affirmance, excuse me, of the right to privacy. In this California case, Jeffrey H. versus Amai Tadlock, the HIV positive plaintiff sued a defense firm for release of medical records in an auto accident that they had obtained in discovery, and that included not only records relevant to the auto accident, injuries from the auto accident, but also his HIV status. They submitted all of the records, including HIV status, in an arbitration. Again, that included not only the records of the injury, but records of HIV treatment. And he filed a complaint against the attorneys alleging invasion of his constitutional right to privacy. And the court there held that the Constitution, California Constitution, created a right to privacy which was broader than the right of the federal Constitution, and that right created a legal and enforceable right to privacy. The Constitution created a legal and enforceable right of privacy, and that it protects against invasions of the right of privacy, the shield of privacy, by individuals as well as the state, as well as both individual and state. And the public policy, in turn, supported his claim to sue the law firm for invading his right to privacy. It's a great case, 25 years old, is existent, and in any kind of California case or claim, I always begin with California Constitution, and then the Jeffrey H. case, with the court saying, yeah, the Constitution does give you a greater protection and does create an enforceable right. Here are some recent cases, and most of the cases and the trend in cases that we're seeing in the area of disclosure of HIV/AIDS is in really kind of a mass disclosure of HIV/AIDS status by an insurance company or a healthcare group or anything like that. We'll get into this in a little bit, that we don't see a whole lot of individual HIV/AIDS cases suing for invasion of privacy. I think primarily because of the stress and anxiety that is created by waiting to get to court for 4 to 5 years in the Bay Area, of filing a lawsuit that has the effect of waiving the individual's right to privacy. But we'll get to that in a little bit. But in the meantime, the big cases have resulted in settlements and not jury trials with significant monetary compensation for victims whose HIV/AIDS status has been disclosed. Many of these cases involve health programs or major healthcare providers that reflect a flaw in the technology infrastructure and day-to-day healthcare operations. Um, the Gilead case was a case that came about because of the way that Gilead um, sent out information about delivering of medication. That was a $4 million settlement. There was also a recent settlement against Aetna, where Aetna um, mailed out its insurance uh, premium notification and used one of those envelopes with a window in it, and it had the name and address of the individual, and below that it revealed Ray HIV medication. That was in the address window, and that recently settled for a significant uh, dollar amount as well. Um, these really cases really underscore, in these broad cases, you're going to get a huge different population of individuals, each of them affected in very, very different ways, as we talked about the disclosure of their HIV/AIDS status, um, mostly, in the mail or properly releasing health information um, uh, in any type of in any type of setting. All right, so that's the common law. We'll get back in a little bit more to how to tailor a claim letter and a demand letter and a lawsuit based upon the common law. But let's take a minute to talk about statutory protections within California that protect HIV/AIDS privacy. Um, they really are the statutory protections in California really are the cornerstone of legal and public health policy in the United States that have reflected the policy against discrimination and stigma of individuals. The laws establish clear guidelines for the confidentiality of HIV-related information in healthcare, employment, education, and government settings. We'll see that the remedies in the statutes applicable more often than not to healthcare providers have kind of limited damages, not significant, but the importance of having and relying upon a statute in your case that provides for the non-disclosure of HIV/AIDS provides a basis for a claim for negligence per se. So there are two remedies. There's a statutory remedy for an award of damages against the individual, but again, they provide the very strong foundation in a complaint based upon the violation of the statute, thereby creating a negligence per se claim in a complaint. Excuse me. Excuse me. There are two federal laws protecting the right to privacy. First is HIPAA, and HIPAA prohibits healthcare providers, doctors, hospitals, labs, from disclosing a individual's healthcare status, all healthcare status, not just HIV/AIDS, all healthcare status to an individual. And HIPAA does have the limitation that there is no personal cause of action based upon a violation of HIPAA. But again, arguably, you can use it as a basis for a negligence per se claim. The Privacy Act, 5 U.S.C. Section 552A, was an act that was created after shortly after the Nixon administration Watergate scandal, and it was created against the backdrop of governmental misuse of personal information. And the Act restricts the collection, use, and dissemination of personal information by federal agencies. So, it prohibits the federal government from disclosing any type of medical record or any type of confidential information that is in a government database, and uh, provides for 4 separate and distinct civil causes of action. 2 of the causes of action provide for injunctive relief, and the remaining 2 causes of action provide for compensatory relief in the form of monetary damages. It provides for the recovery of damages against an agency of the federal government that acted in a willful or intentional manner, not negligent. It's got to be willful and intentional disclosure of confidential records in a government system, outside of that system. And it permits the recovery of actual damages sustained by the individual as a result of the disclosure. One of the cases that I worked on from ALRP was the case of Stanmore Cooper versus FFA and Social Security Administration. And Stan was a gay man who contracted HIV/AIDS and who, because of the stigma of HIV/AIDS, had disclosed his status to 6 individuals in San Francisco. Stan was passionate about flying airplanes. He loved recreational flying. At a time that he was flying airplanes, the FAA had a ban, absolute ban on any individual with HIV/AIDS from getting any type of recreational commercial license from flying airplanes. And that was a result of the stigma that an individual who has AIDS probably is going to have some type of emotional or brain reaction causing the plane to crash. So what you had to do was to certify every 3 years that that you did not have HIV/AIDS. Stan's passion was flying airplanes. He lied. He did not disclose his HIV/AIDS status to FAA 3 times. Stan became very, very sick with HIV/AIDS to the point of almost dying. He ended up in a clinical trial of resurrection project at UCSF and is living a very strong, powerful life now. But when he was sick, he filed a disability claim with the federal government, Social Security Administration, because of his HIV status, AIDS status. And he got his disability benefits, HIV records with Social Security, FAA records, no AIDS status. 9/11 happens. FAA says to Social Security, we want to look for the bad guys who've given phony Social Security numbers to get pilot licenses. Social Security not only gave them Social Security numbers, but they gave Stan's Social Security records to FAA. FAA compared it to the database. He lied 3 times and indicted for 3 felonies. We sued on a whole bunch of different theories, including the Privacy Act, and it got to the Supreme Court and trying to figure out what actual damages was. Actual damages is undefined in anywhere else in the statute or anywhere else in the USC code. And the Supreme Court in the 5-4 ruling held that actual damages was out-of-pocket damages. Stan had no out-of-pocket damages, only emotional distress, and that was the end of his case, except it did have the effect of changing the regulations for sharing of information and strengthen the Privacy Act. Let's talk about state law again on confidentiality of HIV test results, when they can be disclosed, when they can't be disclosed. Again, another great resource for learning about cases and law about what test results can be disclosed, when, by whom, and so on. There are basically two laws within California for labs, healthcare providers, and so on. CMIA and the Health and Safety Code. These prohibit the disclosure of any healthcare information without the consent of the individual. It identifies, excuse me, how the information is to be stored and to maintain. And it provides for a penalty against a healthcare provider, laboratory, or other forms of healthcare providers. It provides for nominal damages of $1,000, as well as actual damages, as well as an administrative fine. And that increases according to the type of conduct, if it was negligent, or if it was willful or intentional. Again, that's one remedy. It's a remedy to get $1,000 in actual damages that you can include in a complaint, but also it becomes a basis for a claim of negligence per se. Health and Safety Code is much more narrow. It prohibits the disclosure of HIV test results. And again, it provides that anybody who discloses the result of an HIV test result to a third party has a penalty not to exceed $2,500. The trick with Health and Safety Code section is that when a test is disclosed that comes from a medical record of the patient who is the subject of the test, the inclusion of that information is not a disclosure for the purposes of the section. So if a doctor discloses, sends out medical records that has the HIV test results in those medical records, that is not, and that's the sole basis for disclosure. That's not a basis for a claim under Health and Safety Code sections. Remember Jeffrey H., there was a disclosure of medical records that contained HIV status and test results. He nevertheless had a claim for negligence, intentional infliction of emotional distress, and negligence per se. So, the penalties for disclosure of test results is limited under these two sections, but nevertheless do provide a basis for a claim of damages. So, all right, let's take a look for remedies for violations. First, we take a look at considering seeking an administrative remedy against, and this is for institutional disclosure. No, it's for an individual as well. File a claim with the Office of Civil Rights. And that triggers a whole investigation by the Office of Civil Rights and it's a very thorough investigation, interviewing witnesses, obtaining documentation, and going to appropriate sites. Once the investigation is completed, they'll issue a letter of whether or not your rights have been violated, and it then issues a letter to, say, a healthcare provider that wants it to come up with a plan of correction. While not providing any type of monetary or injunctive remedy, that nevertheless is hugely helpful. If you get a letter from the Office of Civil Rights that your rights have been violated, very, very helpful in writing a demand letter or in filing your civil rights claim or civil rights lawsuit. All right. This is the meat of it, isn't it? If the ultimate remedy for most of the clients who come to us and tell us about a type of violation of their right to privacy, right to be left alone, the very first thing they want to do is I want to sue them. And I want to take from them everything that they have. Um, Again, with the client needs to appreciate that there are remedies, and if that individual is part of a larger class, the Aetna case that had a settlement of $17 million, where they agreed to pay three states $500,000 to resolve investigations, paid fines to the government, and so on. Attorney General Becerra had a $935,000 settlement against Aetna for the same violation of California privacy laws. But if they're part of a class, that's perfect. There's a remedy, usually not an amount that they will be happy with. But the alternative remedy is to, as an individual, to sue anyone at all, lover, employer, doctor, insurance carrier, anybody. They want to take them for everything that they have, and by God, they're going to get it, and they want you to do it. So the first conversation that we are obligated, I believe, to have with the individual is to walk them through what it's going to take to get everything that they have. The benefits of filing a lawsuit or even making a demand letter is that the client is satisfied with the outcome. They get monetary damages, and they get the comeuppance of the violator. Their dignity is somehow restored. They feel pretty good about that. They want to show that they're right as they are. They want to make the individual hurt and to pay, which is what it is that litigation will do. And they want to, get on with their lives. And then, okay, you tell them that that's what could happen. That's the point of going to litigation. But then, we begin to talk to them about what that is going to cost. They are not going to cough up a settlement only because you filed a lawsuit. They will dig in just as you will have dug in, and that in the course of the irony of it is that the privacy that you want protected, the privacy that you feel has been violated, will be made public. By filing the lawsuit, there is the implied waiver of your right to privacy and confidentiality in your medical history, and potentially your lifetime history of lifetime medical history will be exposed. The defendant will want to get everything. You limit them to their history of living, of being diagnosed, treated for HIV/AIDS. All those medical records are fair game. They come out. You're going to not only have those records come out, but you're going to be put under a long, long, long process of discovery, written questions to you, most painfully a deposition that will ask you about anything and everything that has, whether or not it has to do with HIV. I'm going to try to ask you about your life. The stress that you have experienced by the initial disclosure of HIV/AIDS by an individual will be magnified exponentially in terms of the stress that you will experience in having to share your life medical history with people you don't know, first with the defense lawyer, then with the judge, then with the jury, and so on. Everything that you want protected will be made public. And finally, that the stress that you will be living under will be something that you experienced for years, given the time that it takes a case in San Francisco Bay Area 3 to 5 years to come to trial. think about it, consider it, balance this with pros against cons, and do you really want to do this? Um, Stan Cooper is the only one that said, "Hell yes, I want to do this." Um, every case that I've worked with through ALRP has um, resolved through settlement, not even arbitration, but through settlement, because the power of the case, the power of the story, the power of the narrative that the individual has to tell about the impact of a individual's disclosure, willful, intentional, negligent, or whatever that has had on this individual's life. And they weigh the pros and cons of that as well. And um, apart from Sam Cooper, the cases that I've dealt with over the years have resulted in settlements. Not always a settlement that they expected or wanted, but like I say, a good settlement is one that nobody is happy with. It's an opportunity to be a very forceful advocate, a powerful advocate, standing up for those, um, giving voice to those who have none. Um, these people have been through hell more often than not in their personal lives and their medical lives. And they are grateful for the opportunity of someone to listen to them, someone to tell their story, and someone to become a warrior for them. And that is the strength and power that ALP, I believe, really gives to our clients. Back to pre-litigation. Um, yeah, this is pretty clear about getting to the point of before you um, consider a lawsuit, understand what the applicable law is, do a demand letter. If it's a significant case, they all are significant, but if anyway, evaluate the jury pool, take a look at the local courts, look at the history of awards and settlements, and create a full-on discovery plan. I keep coming back to the demand letter because that's more often than not the only way to go. It's the most powerful way to go. And, involve the client in drafting the letter, writing the letter, uh, uh, you know, become their advocate, give them the voice. Finally, if you do file the complaint, consider whether or not we've got to give pre-notice to the defendant. If it's a claims against a state and federal, you've got to file a claim within a particular period of time, um, and the claim has to be very, very specific. If you're going to do a class action, identify not only this person as a class, but to go into detail about the scope of the class, who might be involved, who's not involved, and so on. One of the issues that we have to consider if you do file a lawsuit is you really don't want to start off the lawsuit by identifying the name of the client, where that becomes open to the world. So take a look at the DOE regulations of how you file and the name of a DOE and so on. One of the things that take a look at the judges and the jury pool. Do you want a jury? Do you want a judge? And so on. Causes of action are really based upon what it is that we've been talking about in the afternoon. The unwanted disclosure of status, invasion of privacy, depending upon the facts of the case. Was it negligence? Was it intentional? Take a look if there's a statutory basis for the claim, negligence per se, emotional distress, and possibly HIPAA as well, if healthcare providers involved. Well, there you have it. It's a scary, scary time, scary, scary scene out there for our clients, well, for everybody. And I want to take a look at what it is that, as I say earlier, that we as panel attorneys for ALRP, what it is that we can do in the sense of privacy, of really giving voice to those who have none and who have suffered possibly the worst event in their lives other than the early diagnosis, that their privacy is invaded and that their lives have been unconsented to disclose to others. All right. Happy to take any questions that y'all might have. And again, thank you, Jake. Thank you to the LP for the opportunity to present this to you.
Absolutely. Thank you, Jim. We've got a question. Martha asks, how do you prepare a client for the ordeal of discovery?
Well, you do a mock. Uh, you go through, okay, I'm a defense lawyer, I'm your lawyer, but here's what that deposition is going to be like. And I'll ask you the questions, you answer the questions. And you go through, okay, let's begin with uh, the first time that you had gay sex. Who was that person? Who was it with? You just go through beginning to end, and you put them through it, and it's going to be painful. They will cry. As you will.
Do we have any other questions? Anybody? Aha. Um, yes. Raquel, do you have a, all I got was yes. Uh, she asks, have you ever sued as a doe?
Oh yeah, always, always. Like I say, you don't want to begin a privacy case with the disclosure of the individual's true name, and so actually, the few times that I have sued, it has been with the exception of Stan Cooper, who was proud of what he was doing. Most individuals, when they do sue, they said, "I don't want my name out there," and there's a way that you can protect that as a doe and keep that doe as protect that individual's name from public record by filing as a doe.
Oh, Jeff has a statement. He says, great presentation, Jim. Thank you so much. Follow-up question. Have you successfully sealed or redacted medical records in these cases?
Yeah, yes. Again, with um, if the issue is limited to HIV/AIDS, and there are records about, an employment injury or anything in the health history that has absolutely nothing, even remotely, to do with gay life or HIV/AIDS, then yeah, that's redacted. It's got nothing to do with anything. And if they want to fight about it, I'll fight it.
Hmm. Any other questions? Jeff asks, is the AI generated demand letter you referenced at the beginning available?
Yeah, it's in the packet that I included. Um,
Which I will send out to our folks.
oh, the demand letter? No, not. I'm sorry. The demand letter is done the old-fashioned way. Um, that was based on research and needs significant updating because included in there, I have examples of verdicts and settlements, and I haven't changed that in a good amount of time. No, the demand letter is not. Well, that's not a bad idea. I think I'd like to try that and see how that works out.
Yeah, my partner was actually talking about that they've been getting chat GBT generated demand letters and motions and stuff, and still needs some work. You can always kind of tell when it's AI generated, just in terms of the structure and the grammar they use. And oftentimes, as somebody, I'm a historian myself, and I often see AI chat GBT generated like answers to historical questions. The hilarious thing is that about 60% of the time they're wrong. Like I don't, they're getting the information by trawling the internet. But like with most things, the majority of people are usually wrong about things, and that's why we still have experts to draft stuff like that, right?
Exactly. You know, it's like when you somebody writing a novel, I forget who it was that says, might have been early. Anyway, they say that uh, the writing begins with the editing. You get the first draft, you get that out there,
Yep,
then the writing is the editing. And that's true regardless of what the source is. If the source is you on your own or ChatGPT or something like that, that's only a start. That's a start.
exactly.
Yeah.
Any other questions? Surely we must have one or two more. Eine Frage für uns. Stephen Spano, whom we know is one of our great attorneys at ALRP, says, "Thank you so much as always, Jim. You indicated that stigma has been baked into American culture, and I agree. But I'm curious about how the US pairs up against other nations regarding stigma-related laws."
It's always worse. It's always worse. Where you've got death sentences in Eastern European and African nations. But there's, Stephen, it's no comfort to individuals here telling them that it could be worse if you lived there.
Right.
But it's I don't know how you qualify this or quantify this the stigma, but that's a good point that it is a lot worse out there, and that's why the no stigma movement is such a strong, powerful movement. It's an international movement worth checking out.
Uh, Stephen says, "Oh, I would never, but thank you." Um, yeah, I think about that, especially, I mean, certainly Eastern European countries, African countries, very religiously conservative countries. How do you think it stacks up against sort of Western European nations that are a lot more secular, like the Scandinavian countries, Britain, Germany, the Low Countries?
How does it stack up?
Yeah.
I think the more liberal countries are more accepting uh, of individuals for who they are. Um, yeah, I'm not quite sure how to answer that.
Any other questions before we log off? Any more question, comments, threats?
And then let me
Ah,
just, as Richard Nixon used to say, let me say this about that. As I started off, I'd be more than happy to talk to any of you about any of the cases that you have, any questions that you have about individual cases that are coming up. And you got my email at the start of this thing, so I'd be happy to do it.
well, the only comments we have are thank you and great information. Well, thank you so much, Jim. This has been great. I feel like more and more these things kind of just remind us of where things stand, and that sometimes that there actually are safeguards when it seems like the president just disregards the rule of law, but yet it's still there. So I'm glad everybody could attend. Thank you so much for teaching this session, and we have more thank yous and very informative rolling in. For everybody else, send in your evaluations, and we'll send you your MCLE credits. Of course, Jim, I'll send you your credit here shortly for presenting. Thank you, everybody, again. Our next MCLE, I believe, is December 14th, which will be on immigration. Jim?
Two more things.
Mhm.
First, always quote John Lewis at the end of this: "Go out and make some good trouble." And
Yes,
Jake, again, I apologize for being so technology inept and getting this whole thing started. And I'm grateful for your patience. Thank you.
absolutely. It was a pleasure. We have to do this again soon. Our next MCLE, I think, is on December 14th. It'll be on immigration topics, and I believe one of our own in-house attorneys, Slater Stanley, will be co-hosting that one. We'll send out the details once they're available in the next week. I want to wish everybody a happy Thanksgiving coming up, and I hope everybody gets a chance to be with their families and to, at the very least, kick their feet up and eat some turkey. So thank you
Well,
again, Jim, and thank you everybody else. Take care.